How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old and you've been out literally, she's been on the lam for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know, do they really want, are they going to
I
come?
mean, that's like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone and the fact that it's been in forfeiture status since 2015. This isn't one where it's a to-be warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want
$1,500, Judge. My client has expressed to me that she is a college student. She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
The thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at $5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County.
Go.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you or your family is able to post? Because if not,
5,000 cash?
it's 5,000.
Oh, no, I have a deaf baby. I'm a single parent. My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind.
What did she waive?
Right off the bat, 227?
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So If you withdraw it and you don't make the bond, you lose all that time. And you basically it's
Start over.
told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence, the Marsh Sheriff's Office says she's in our custody and her persons is here. And for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they will recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
Well, but we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know, but.
I'll stand down. Thank you, Judge.
So hold on.
Yeah.
So
Yes, sir.
I'll let you guys go talk.
Okay,
I
sir.
don't want you to say something here that you might invariably regret because it's in front of everyone, you know? Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, you know, but a reasonable amount.
I'm General Litigation.
What makes this hearing so fascinating is that it wasn't just about money, it was about accountability. The judge made it crystal clear that after nearly a decade, excuses were no longer enough. Yet, even while taking a tough stance, he left the door open for compassion and a reasonable solution. Now the big question is, if you were in the judge's position, would you have lowered the bond further? Or was this the right balance between justice and responsibility? Let us know in the comments. And don't forget to like, subscribe, and turn on notifications for more courtroom breakdowns and real-life legal drama.